I remember the exact moment my life split in two. It was a Tuesday morning in late October, and I was sitting at my kitchen table with a cup of coffee going cold beside me, scrolling through emails I'd been putting off for days. The house was quiet in that particular way it gets when everything is about to change, not peaceful but held, like the air before lightning. The email subject line read, "Notice of legal intent, estate of Gerald and Patricia Okafor." My parents' names, my name in the recipient field, and the logo of a law firm I didn't recognize stamped at the top like a brand. I set down my coffee. I read it twice. Then I read it a third time because my brain kept rejecting the words, kept trying to rearrange them into something that made more sense. They were suing me. Not for something small. Not for a misunderstanding about a loan or a property line dispute. My parents, the two people who had brought me into the world, who had sat in the front row at my college graduation, who had called me every Sunday for 31 years, were taking me to court to reclaim, and I quote, "all assets, properties, financial accounts, and material possessions transferred to or accumulated by Adaeze Okafor during the period of parental financial support, including but not limited to residential property, investment accounts, vehicles, jewelry, and personal effects." Everything. They wanted everything. My name is Adaeze Okafor, and at 31 years old, I had built what most people would call a good life. Nothing extravagant. A small house I'd bought with my own savings in a quiet neighborhood outside of Columbus, Ohio. A reliable car. A modest investment account I'd been feeding $20 at a time since I was 23. A few pieces of jewelry that had belonged to my grandmother, which she had placed in my hands herself 2 weeks before she died and whispered, "These are yours, baby. Don't let anyone take them from you." I had a career I was proud of. 7 years as a pediatric occupational therapist, working with children who needed someone in their corner. I had built my life deliberately, carefully, like someone who had always known the ground beneath her feet wasn't guaranteed. Now I understood why I'd always felt that way. I called my best friend Neka first. She picked up on the second ring. "They filed papers," I said. My voice came out flat, which surprised me. I had expected to cry. Silence on her end. Then, "Filed papers for what?" "They're taking me to court. They want everything I own." Another silence, longer this time. "Adaeze." Her voice dropped to something careful and low. "What exactly does the filing say?" I read her the key line, the one about all assets, properties, financial accounts, and material possessions. When I finished, she was quiet for so long I thought the call had dropped. "Neka, I'm here." A breath. "I'm just trying to figure out what kind of people do this to their own child." I had been asking myself the same question since the moment I was old enough to see my parents clearly. The trouble was I already knew the answer. My parents, Gerald and Patricia Okafor, were people who believed love was transactional. Not cruelly, not with mustache-twirling malice, but structurally the way some people believe the sun rises in the east. Love, in their world, came with a ledger. Every gift had a price. Every sacrifice had an invoice. Every act of care was a deposit against a future withdrawal they intended to make. Growing up, I hadn't understood this. I had only understood that I was never quite doing enough, never quite grateful enough, never quite becoming the version of myself they had invested in. I was supposed to be a doctor, not a therapist. I was supposed to marry the man they had selected from our church community, not end an engagement at 26 because he had told me, matter-of-factly over dinner, that my job would need to become part-time once we had children. I was supposed to stay close, stay available, stay useful. Instead, I had built a life of my own. And apparently they had decided to collect. I spent that first evening reading the legal filing in full, 3 times, taking notes in the margins the way I used to study for exams. The complaint was 42 pages long. It had been clearly constructed over time, not thrown together in anger, but assembled. Organized. There were receipts in the attachments. Invoices. A spreadsheet with dates going back to my childhood. Listing expenditures with line items I could barely believe. School lunches from 2002. A winter coat from 2005. Piano lessons I had quit after 4 months, because my teacher made me cry. My father's contribution to my college application fees. A birthday party when I turned 16 that I had spent half of hiding in the bathroom because the guests were all adults from their church who kept asking me about my future plans. They had logged all of it. They had been logging all of it for years. But it was the last page of the filing that made my hands go still on the table. It was an addendum, added almost as an afterthought. And it contained information that told me this lawsuit was not really about money. It was about something else entirely. Something I hadn't known they were aware of. My heart rate spiked as I read the final paragraph again. Because if what it implied was true, then this lawsuit was never about recovering debts. It was about destroying me before I could use what I knew. I need to take you back to understand what that final paragraph meant. 18 months before the lawsuit, I had been home for Easter. Not willingly. I had been guilted into it by a phone call from my mother that lasted 45 minutes and covered, in roughly equal measure, my ingratitude, her blood pressure, my absent future children, and the sacrifices she and my father had made that I apparently treated like nothing. I had packed a bag, driven the 2 hours to their house in Dayton, and arrived resolved to get through 3 days without a single argument. I had lasted about 14 hours. It was the second morning. I'd woken up early, as I always do, and come downstairs to make coffee before anyone else was awake. My parents' house is one of those large, slightly formal places where everything has a designated spot and deviation is noticed. The kitchen was spotless. The living room was sealed off like a museum. And the door to my father's study, which had always been kept locked, was standing open. I don't know what made me go in. Curiosity, maybe. Or something older than curiosity. Some instinct that had been quietly running calculations my conscious mind hadn't caught up to yet. The study smelled like cedar and old paper. My father's desk was a massive mahogany thing, always clear of anything personal. But that morning, there was a folder sitting on top of it, open, with papers fanned out across the surface like someone had been reviewing them in a hurry and gotten interrupted. I told myself I was just going to glance. What I saw instead changed everything I thought I knew about my family. The papers were financial documents, bank statements, wire transfer confirmations, and something that looked like a business registration for a company I had never heard of called Meridian Holdings LLC. The wire transfers were substantial. Not thousands. Hundreds of thousands, moved in chunks over a period of years, between my father's personal account and Meridian Holdings, and then from Meridian Holdings to a second account with a name I didn't recognize. I was a pediatric OT, not a forensic accountant. But I'd grown up watching enough true crime with NECA to know what money laundering looked like in broad strokes. I took photos on my phone. My hands were steady, which surprised me. I rearranged the papers exactly as I'd found them. I walked out of the study, pulled the door to the same position it had been, and went to the kitchen and made my coffee. When my father came downstairs 20 minutes later, I smiled at him over the rim of my mug and asked if he'd slept well. He said he had. I drove home that afternoon, claiming a work emergency. For 18 months, I had done nothing with those photos. I hadn't reported anything. I hadn't confronted my parents. I had simply held the information the way you hold a burning coal, carefully, at a distance, aware that it could destroy you if you weren't paying attention. I had told only one person, NECA. And I had told her only after making her promise that if anything ever happened to me, she would know why. She had called me paranoid. After I read that final page of the lawsuit, I called her back. The addendum, I said when she picked up. They mention the Easter visit. They say I was seen accessing private documents without authorization. They're claiming I took confidential business information and that I've been using it too. I stopped. Took a breath. They're describing it as blackmail, NECA. They're accusing me of blackmail. The silence on her end was the kind that meant she was revising her earlier assessment. You were right, she said quietly. I know. Adaeze, they're not trying to win a lawsuit. They're trying to bury you. I know that too. What I didn't know yet, what I couldn't have known sitting at my kitchen table with cold coffee and a 42-page document, was how far they had already gone to prepare for this. I didn't know about the witnesses they had lined up, the character references they had quietly assembled, or the specific strategy their attorney had designed to make sure I walked out of that courtroom with nothing. I didn't know that my father had made a phone call 3 days before filing the suit, a call to my employer's HR department. I found out about that the next morning when my supervisor asked me to come in for a meeting before my first patient. And the look on her face when I walked in told me this was not going to be a good conversation. My supervisor's name is Dr. Renata Wells, and she is one of the most even-keeled people I have ever met. In 7 years, I had seen her handle a parent screaming in the hallway, a billing system crash that wiped 3 weeks of records, and a pediatrician who threw a clipboard. And in each case she had remained so calm she seemed almost bored by the drama around her. She was not calm that morning. She was sitting behind her desk with her hands folded on top of it and a HR folder open in front of her. And when I came in and closed the door, She looked at me the way you look at someone you genuinely like who has just brought trouble through your door. Sit down, Adaeze, she said. I sat. I received a call 2 days ago, she said. From a man who identified himself as your father. The coffee I'd had that morning turned to acid in my stomach. He made several claims about your conduct. She glanced at the folder, but didn't open it. Specifically, he alleged that you have a history of financial deception. That you have manipulated family members into providing monetary support under false pretenses, and that this behavior may be reflected in your professional conduct as well. A pause. He also suggested that you had been accessing confidential documents that didn't belong to you and using the contents as leverage. I kept my face very still. This was a skill I had learned young, in a house where showing the wrong emotion at the wrong moment invited consequences. He filed a formal complaint with our HR department, Dr. Wells continued. I want to be transparent with you about that, and I want to give you the opportunity to respond. I thought about the 42-page lawsuit, the spreadsheet of school lunches, my grandmother's jewelry listed as a recoverable asset, the wire transfers and the open door, and the 18 months I had spent holding a burning coal in careful hands. He's suing me, I said. He and my mother filed a civil lawsuit 3 days ago claiming I owe them for the cost of raising me. They want my house, my car, my savings account, and my grandmother's jewelry. I paused. The complaint they filed with HR is a tactic. They want to damage my employment, so I have less resources to fight the lawsuit. Dr. Wells looked at me for a long moment. That's a serious claim. I know. I have the filing documents. I can bring them in today. Another pause. Something shifted in her expression. Not relief exactly, but a kind of recalibration. I'd like to see them, she said. For the record, I want you to know that receiving one phone call from a parent is not the basis for any employment action. But I need to follow process here. HR will need to do a brief review. I understand. Are you okay? She asked. It was quiet and genuine and almost undid me. I'm working on it, I said. I drove home that afternoon and sat in my car in the driveway for a while. The street was quiet. My neighbor's dog was barking somewhere distant. The leaves on the oak tree at the edge of my yard had gone copper and gold, and a few of them drifted down in the still air while I sat there trying to think. I needed a lawyer. I had been telling myself I could handle the initial filing on my own, read the documents, write a response, file it with the court clerk. I had been wrong. What my parents were doing was not a confused, elderly couple trying to recoup some sentimental loss. This was organized, coordinated. They had legal representation that had clearly spent real time constructing that complaint. They had extended the attack beyond the courtroom before it had even begun. I called Neka. She picked up before the first ring had finished. I need a referral, I said. A good one. Already ahead of you, she said. I've been doing research since last night. There's a woman, an attorney, civil litigation, family disputes. Her name is Beverly Crane. She's won some significant cases involving parental financial claims. I already sent her your documents. I blinked. When did you do that? Last night, around 2 a.m, when I couldn't sleep because I was too angry on your behalf. A beat. She wants to meet you Thursday. I leaned my head back against the headrest and closed my eyes. Neka, I said. Don't thank me yet. Wait until you hear what else I found. My eyes opened. I did some digging on Meridian Holdings, she said. Her voice had gone careful in a way that made the back of my neck prickle. Adaeze, I think your father's financial situation is not what you think it is. I think the reason they're doing this, the real reason, is because they need the money. Urgently. She paused, and in that pause I felt the shape of something large and complicated materializing in the dark. How urgently? I asked. What she said next made me understand, for the first time, that the lawsuit was not just about control or punishment or the particular cruelty of a transactional love finally presenting its bill. It was about survival. Their survival. At the direct expense of mine. Beverly Crane's office was in a converted Victorian house near downtown Columbus, with original hardwood floors and the kind of organized clutter that suggested a person who thought faster than they could file. She was in her mid-50s, with natural gray locks pulled back from her face and reading glasses pushed up on her forehead, and she shook my hand with the kind of grip that told you exactly where you stood before she said a word. Sit, she said. Not unkindly. I've read the filing twice. Tell me your version. I told her everything. The full version, not just the lawsuit but the Easter visit, the open study door, the photos on my phone, the wire transfers, the Meridian Holdings documents. I told her about my father's call to my employer, and about what Nneka had found when she dug into the company's public records. Beverly listened without interrupting. She took notes in a leather journal with a fountain pen, which I found oddly comforting. There was something permanent about ink. When I finished, she set the pen down and looked at me. "Your friend is right," she said. Meridian Holdings filed for dissolution 14 months ago. Before that, there were 2 civil judgments against it from business partners. One for breach of contract, one for fraudulent misrepresentation. The total judgment value was approximately $430,000. She let that land. "Your father is listed as the sole director." $430,000. I thought about the spreadsheet in the lawsuit, about all those line items meticulously cataloged since my childhood. I did the math silently, and arrived at a number that didn't come close. "They can't collect $400,000 from a lawsuit against me," I said. "The complaint doesn't get anywhere near that value." "No," Beverly agreed. "But a successful lawsuit against you does a few things. It liquidates your assets, which gives them some relief. It establishes a public record of financial misconduct on your part, which preempts any complaint you might file against them. And," she paused here, and her eyes were direct and level, "if they can characterize what you photographed as theft of confidential business information, they may have grounds to pursue a separate action that creates enough legal noise to obscure what's actually in those documents." The room was very quiet. "They're not just trying to take my things," I said slowly. "They're trying to discredit me before I can hand those photos to anyone." "That's my read," Beverly said. "The question is, have you shared those photos with anyone other than your friend?" "No." "Good. Don't." "Not yet." She picked up her pen again. "Now, tell me about your grandmother's jewelry specifically. The filing lists it with a valuation. Where did that valuation come from?" I frowned. "I don't know. I've never had it appraised." Beverly's expression shifted almost imperceptibly. "They listed a specific figure. $12,000. My grandmother was not a wealthy woman. I don't know where that number came from." "I do," Beverly said. She turned her legal pad around so I could see. "They had it appraised 18 months ago." A pause. 2 weeks after your Easter visit. The air went out of the room. "They had appraised jewelry they no longer possessed. Jewelry my grandmother had placed in my hands before she died. Which meant they had either commissioned an appraisal based on their own records and descriptions, or they had accessed the jewelry without my knowledge." "Where do you keep it?" Beverly asked. "At home. In a lockbox. I want you to go home tonight, open that lockbox, and confirm everything is there." Her voice was steady but urgent. "And I want you to photograph every piece with a timestamp." I drove home with both hands tight on the wheel. The lockbox was in my closet, in the back behind my winter coats, tucked behind a pair of boots I only wore twice a year. I knew the combination by memory, the date my grandmother was born reversed. I had put the jewelry there myself the week after she died, along with the brief handwritten note she had given me with it. I found the box, spun the combination, and opened it. Everything was there. Every piece undisturbed. My grandmother's pearl earrings, the thin gold chain she had worn every day for 40 years, the garnet ring she had called her going-out ring, even though in her last decade she had rarely gone out. And under the velvet tray, still folded in the same soft crease, her note. "These are yours, baby. Don't let anyone take them from you." I photographed everything. Time-stamped. Backed up to the cloud immediately. Then I sat on the closet floor for a moment with the note in my hands, and I let myself feel it, all of it. The grief and the anger and the particular exhaustion of being someone's child when that someone had decided your existence was a debt to be collected. I let myself feel it, and then I put the note back, closed the box, stood up, because Beverly had also said something else before I left her office. Something she had said carefully, watching my face. She had said, "There's one more thing I need to tell you about the filing. Something I think you missed on your first read. Something about a witness they've listed." She had told me the name, and I had not recognized it at first. But driving home, it had come to me slowly, the way a face comes into focus from a photograph. It was someone I had trusted. Someone who had been in my home. Someone who had sat at my kitchen table and eaten my food and listened to me talk about my life with what I had believed completely was genuine friendship. I pulled into my driveway and sat in the dark. How long had they known this person was reporting back to my parents? How much had I said? Her name was Kayamika, and I had met her 3 years earlier at a professional development conference for pediatric healthcare workers. We had ended up at the same lunch table, gotten into a conversation about a panel presentation that had frustrated us both, and exchanged numbers at the end of the day. She was warm and funny and easy to talk to. She worked in healthcare administration, lived 20 minutes from me, and had become, over 3 years, one of those comfortable presences in my life. Not a best friend like Neka, but someone I saw for coffee every few weeks, someone I called when I had a funny story that couldn't wait, someone I had given a spare key to once when I'd locked myself out and needed someone to let the plumber in. A spare key. She was listed in my parents' filing as a material witness who would testify to my pattern of deceptive financial behavior and my admission of accessing confidential documents. The specific reference was to a conversation dated 14 months ago, 4 months after Easter, in which I had apparently, according to this filing, confided in the witness regarding the theft of business documents and her intent to leverage said documents for personal gain. I had told Kayamaka about the Easter visit. Not everything. I hadn't mentioned Meridian Holdings by name, hadn't described the wire transfers in detail. But I had told her that I had seen something in my father's study that worried me. That I had taken photos. That I wasn't sure what to do with them. I had said it the way you say things to friends. Casually over coffee, processing out loud. And she had apparently filed it away, word for future use. I called Neka. Kayamaka, I said. A pause. From the conference? She's listed as a witness in the filing. My parents have her as a material witness. She's going to testify about a conversation we had over coffee 14 months ago. My voice was steady. I was proud of how steady it was. She has a spare key to my house. Get the locks changed tonight, Neka said immediately. Tonight, Adaeze, not tomorrow. Is there anything in your house that could be removed or altered before the court date? I was already mentally cataloging. The lockbox. My files. My laptop. The external hard drive where I had backed up photos, financial documents, years of personal records. I'll call a locksmith, I said. I'll come over, Neka said. I'm not letting you be alone tonight. She arrived an hour after the locksmith left, with Thai food and a legal notepad and the same focused energy she had brought to every crisis in the 15 years I had known her. We sat at my kitchen table, the same table where I had read the email that started all of this, and we worked. We made a list of everything I needed to document and protect. We went through the filing again, this time with Beverly's notes alongside it, flagging every claim and cross-referencing it with what I could actually prove. We talked through Kayamaka, what she knew, what she could plausibly testify to, and how her testimony might land with a judge. The blackmail accusation is the most dangerous part, Neka said. If they can make that stick, even partially, it reframes everything else. It makes you the aggressor. It makes the lawsuit look defensive. Beverly said the same thing. So how do we counter it? I looked at my hands on the table. Beverly thinks the Meridian Holdings documents are our best asset. If we can establish that what I photographed represents genuine financial misconduct, not just family drama, then the accusation that I was going to use them as leverage becomes complicated. Because what looks like blackmail looks very different if it's actually whistleblowing. Neka was quiet for a moment. Have you thought about going to the authorities? Beverly and I talked about it. It's not straightforward. The documents are 4 years old, the company is dissolved, and any investigation would take time I may not have. But it would shift the narrative. Yes. We sat with that for a moment. There's something else, I said. Beverly asked me about my parents' financial records specifically, not Meridian, but their personal accounts. She said if we can demonstrate they have an urgent financial motive, it contextualizes the lawsuit completely. It stops looking like a principled parental claim and starts looking like what it is. I paused. She asked if I had any access to information about their finances that would be legal for me to use. Neka tilted her head slowly. And do you? My grandmother's estate, I said. When she died, I was the executor. I have records from that process, disbursements, valuations, the full accounting. And some of it involves transfers my father received from her estate that were later disputed by my uncle. I paused again, remembering the months after my grandmother's death, the quiet family tension, the conversations that stopped when I walked into a room. My uncle filed a formal objection with the probate court. It was eventually dropped, but the records still exist. Neka's eyes had gone very focused. Adaeze, are you telling me that your parents may have received, or misappropriated, part of your grandmother's estate? I'm telling you that there's a probate dispute on record that was never fully resolved, I said carefully. And I'm telling you that my grandmother gave me her jewelry specifically because she wanted me to have it. Not my parents. Me. We looked at each other across the table. Tell Beverly, Neka said. I already had my phone in my hand. But before I could dial, a notification appeared on my screen. An email. From a name I had never seen before, with a subject line that sent ice straight through my chest. Ms. Okafor, I have information about your parents that you need to see before your court date. Please call me. I showed Neka the screen. She looked at it, then at me. Are you going to call? She asked. I called. His name was David Asante, and he was an accountant. A former accountant. Specifically, he had worked for the firm that had managed Meridian Holdings books for nearly 6 years before the company dissolved, and he had left under circumstances he described, carefully and with obvious legal caution, as a significant disagreement about professional standards. We met in a coffee shop on a Saturday morning. He was a compact man in his late 40s, dressed in a blazer and carrying a slim briefcase, and he had the careful, methodical way of speaking that comes from years of working with numbers. Every sentence accounted for before it left his mouth. I want to be transparent, he said, once we had settled at a corner table with our drinks. I've been watching this family's financial activity for a while. Not professionally anymore. Personally. Because what I saw when I worked on those accounts, what I was asked to do, is something I should have reported years ago and didn't. I kept my expression neutral. What were you asked to do? He looked at his coffee. Have you heard of a financial arrangement called beneficial interest transfer? I hadn't. He explained it quietly, in plain language, drawing a simple diagram on a napkin with a ballpoint pen. The short version, it was a mechanism by which the real ownership of an asset, a property, an account, a business interest, could be obscured on paper while the actual benefit of that asset flowed to a different party. Used legitimately, it had applications in estate planning and business structuring. Used illegitimately, it was one of the cleaner ways to hide money. Meridian Holdings, he said, was structured specifically to receive and redistribute funds that your father was not supposed to have access to. I went still. Where did the funds come from originally? He met my eyes. Your grandmother's estate. The coffee shop noise seemed to recede, the way sound sometimes does when your brain needs to process something significant. My grandmother died 4 years ago, I said. She had a modest estate. A house, some savings, the jewelry. My father received his share as a beneficiary. My uncle disputed it, and eventually dropped the claim. Your uncle dropped the claim, David said, because he was approached privately and offered a separate sum in exchange for withdrawing the objection. He paused. That sum came from Meridian Holdings. I thought about the probate records. About the dispute that had quietly vanished. About my uncle, who had been stiffly polite at every family gathering since my grandmother's death, and never quite explained why. My father used my grandmother's estate money to pay my uncle to drop a complaint about my grandmother's estate, I said slowly. That is what the records indicate. He opened the briefcase and slid a folder across the table. I've been compiling this for 2 years. I didn't know what to do with it. I was afraid of my own liability. He looked at me steadily. But when I saw the lawsuit, when I saw what they were doing to you, I couldn't sit on it anymore. Inside the folder were bank statements, internal memos from the Meridian Holdings accounting, a notarized statement from my uncle's former attorney about the terms of the withdrawal, and a timeline that mapped the movement of money from my grandmother's estate into Meridian Holdings and out again, including the payment to make my uncle disappear. My hands were perfectly still on the table. I had learned a long time ago not to let them shake when it mattered. Why are you giving this to me? I asked. Because you're the only one they're actively trying to destroy, he said. And because my daughter has a pediatric OT, who she calls her favorite person in the world. I don't know if it's you, but it made me think about what kind of people do that work, and what it says about you that you chose it. He paused. I thought you deserved a fighting chance. I called Beverly from the parking lot before I had even reached my car. She listened without speaking for 2 minutes. Then, how solid is his documentation? It looks solid, but I don't know how to evaluate it fully. He's a trained accountant, he was directly involved, and he has original documents. Can he be deposed? He said he was willing. He said he would testify if it came to that. A pause on Beverly's end, the kind that meant rapid mental calculation. This changes the posture of the entire case, she said finally. You went from defending against a predatory claim to having affirmative evidence of the misconduct underlying that claim. This is no longer just a family dispute, Adaeze. This is fraud. I know. I'm going to need to file an amended response. And I need to make some calls. Another pause. Are you safe? Is everything at your house secure? Locks are changed. Everything is backed up. Good. Don't talk to your parents. Don't respond to any communication from them or their attorneys without running it through me first. She was quiet for a moment. One more thing. I looked into Kayamaka. I had almost forgotten in the wait of the last hour about Kayamaka. And, I asked. What Beverly told me next made everything that had happened make a different kind of sense. The kind of sense that makes your chest ache not with anger, but with something more complicated. The particular grief of realizing that a betrayal you're living through didn't start yesterday. It started years ago. And you missed every sign. Beverly had done what Beverly does. She had been thorough. Kayamaka, it turned out, was not simply a friend who had turned informant under pressure or in a moment of weakness. She had a pre-existing connection to my parents' church community that predated our meeting at the conference by at least 2 years. Her aunt was a member of the same congregation as my mother. The two families knew each other. The conference where we met, the conference where we had ended up at the same table and struck up a conversation that had felt so organic, so accidental, had been attended by Kayamaka because someone had paid her registration fee. Beverly had obtained a copy of the conference registration records through a standard discovery request. The fee had been paid by a third party. The third party traced back to a checking account. My parents' checking account. I had not stumbled into a friendship with Kayamaka. I had been guided into one. For 3 years, she had been sitting across from me at coffee tables, listening to me talk about my life, and feeding it back. Not viciously, I don't think, even now, that she hated me. I think she was someone who had been asked to do a thing and had rationalized it enough to keep doing it. Sometimes people do that. Sometimes love or loyalty or money or all three makes people capable of things they wouldn't recognize in themselves. But understanding it didn't make the table across from me feel any less empty. I told Neka over the phone that night, and she was so angry she had to put the phone down for 30 seconds. When she came back, her voice was controlled in the way it gets when she's containing something large. 3 years, she said. 3 years. She was in your house. She had your key. I know. Adaeze. A breath. How are you? I thought about it. Strangely okay, I said. I think I've spent so long being vaguely afraid of something I couldn't name that now that it has a shape, it almost feels better. Like, I can see it now. I can plan against it. That's not healthy. Probably not. But it's where I am. The court date was 6 weeks away. Beverly and I spent those weeks building a case that had started as a defensive measure and was now something more substantial. David Asani's documentation was authenticated by a second forensic accountant Beverly brought in, a woman named Dr. Priya Mehta who specialized in estate fraud cases and who, when she reviewed the Meridian Holdings records alongside the probate documents, said to Beverly with clinical precision, "This is one of the cleaner examples of probate asset diversion I've seen in years." Clean, in forensic accountant terms, means easy to prove. My uncle, when Beverly's associate reached out to him with a carefully worded inquiry, agreed to provide a statement. He was retired now, living quietly in Maryland, and his willingness to talk came through not as anger but as relief. The particular relief of someone who has been carrying a weight for a long time and finally been offered a place to set it down. He confirmed everything. He had received a private payment in exchange for dropping his probate objection. He had believed at the time that it was a settlement, a way of avoiding a messy dispute. He had not known, or had chosen not to examine, where the money came from. He also said something Beverly reported to me verbatim. I always felt bad about Adaeze's grandmother's jewelry. Mama was clear about who was supposed to have that. She told all of us. Gerald and Patricia both heard it directly from her. My grandmother had said it in front of witnesses. When Beverly told me that, I sat with it quietly for a moment before I responded. Okay, I said. Okay as in I'm ready. I paused. I want to go to court, Beverly. I'm done defending. I want to make the case. Beverly was quiet for a moment on her end. Then, I was hoping you'd say that. There was one more thing that needed to happen before the court date. One more piece. My parents, through their attorney, had sent 2 more communications since the filing. The first was a revised demand that dropped some of the minor line items from the complaint. The school lunches, the childhood expenses. Likely because their attorney had told them it was going to look absurd to a judge. The second was a personal letter from my mother. I read it once. It was 2 pages long. It was written in the language of hurt, in the cadence of a woman who genuinely believed that love and ownership were the same thing, that the cost of raising a child was a debt the child owed back, that I had taken something from them simply by becoming a person who was not entirely theirs. She used the word ungrateful 7 times. I counted. She did not use the word love once. I gave the letter to Beverly without responding. Beverly filed it with our documentation as evidence of the underlying motivation for the suit. 2 days before the court date, I drove to Dayton. Not to my parents' house. I parked instead at the church they had attended my entire childhood. The brick building on Elmwood where I had sat in a pew every Sunday for 18 years, where I had been confirmed, where I had sung in the youth choir, where I had first understood that the community around me saw my parents as pillars and saw me as an extension of their story. I sat in the parking lot for about 20 minutes. I wasn't praying exactly. I was remembering, trying to hold the full picture of it. The genuine warmth of Sunday mornings, alongside the particular loneliness of being a child whose parents loved their image of you more than the actual you. The community that had been real even when it was also a performance. The childhood that had been mine, whatever else it had been. I drove back to Columbus. The next morning, Beverly called with an update on the final trial preparation. She went through our witness list, the documentary evidence, the specific arguments we planned to make. Then she paused. Their attorney filed something yesterday, she said. A motion to suppress David Asante's testimony, on the grounds that his documentation was obtained in breach of his non-disclosure agreement with Meridian Holdings. I felt a beat of fear. Can they do that? They can file it, Beverly said. Whether the judge grants it is a different question. But there's a wrinkle. What wrinkle? The NDA was between Asante and Meridian Holdings LLC. Meridian is dissolved. Their attorney filed the suppression motion on behalf of your father, but your father was not a signatory of the NDA. He was a director. A pause. It's a creative argument, but I think it fails. And I think the judge will see it for what it is. A last-ditch attempt to keep damaging information out of the record. She paused one more time, and I could tell there was something else. Beverly, I said. What aren't you telling me? Their attorney also filed a personal character complaint with the Ohio State Bar against me this morning. Her voice was entirely steady. Frivolous. I've seen this tactic before. It means they're scared. I took a breath. Beverly. Don't apologize. Don't you dare apologize. A beat. Get some sleep. We have court in 48 hours. I went to bed early. I lay in the dark and stared at the ceiling and thought about my grandmother. About the note. About what she had known near the end, when she pressed that velvet pouch into my hands and looked at me with eyes that had seen a long life and said what she said. Don't let anyone take them from you. I was starting to understand that she hadn't only been talking about jewelry. The courthouse in Columbus was an older building. Limestone exterior, high ceilings inside, the particular acoustics of large spaces where important things have been decided for decades. I arrived 40 minutes early with Beverly and Nneka, who had taken the day off work and was dressed like she was there to testify herself. Structured blazer, quiet authority. My parents arrived 15 minutes after us. I had not seen them since Easter, 18 months ago. My father was wearing the charcoal suit he reserved for formal occasions. I had watched him pack it carefully into a garment bag every time there was a funeral or a graduation. My mother was in a deep burgundy dress, her hair done carefully, her posture composed. They walked in with their attorney, a tall man named Hargrove who moved with the confident energy of someone who had prepared for a scenario he expected to control. My father did not look at me when he came in. My mother did. Just for a moment, a long, searching look I couldn't fully read. Was it regret? Was it calculation? Was it both all at once, the way feelings in a family that has broken down are always both at once? I looked away first. Judge Loretta Washington was in her mid-60s, with close-cropped silver hair, and reading glasses she wore on a chain around her neck. She had been on the bench for 22 years, Beverly had told me. She had seen every variation of family dissolution that money and pride and cruelty could produce. She opened proceedings with a brief summary of the case before her, and then looked over the top of her glasses at both tables. This is a civil action, she said, filed by the plaintiffs Gerald and Patricia Okafor against the defendant Adaeze Okafor for recovery of assets and compensation. I've reviewed the initial filing and the defendant's amended response. Before we begin, I want to note that I have also received and reviewed a pre-hearing motion to suppress witness testimony and a related exhibits challenge. I'll address the admissibility question after opening statements. She paused. Mr. Hargrove, you may proceed. Hargrove's opening was polished. He framed the case as a straightforward parental claim. A family that had invested substantially in their daughter's future, who had provided financial support, housing assistance, educational opportunities, and ongoing material support, and who now sought a return of that investment in the context of what he described, carefully, as a breakdown of trust. He did not use the word blackmail in opening. He used the phrase inappropriate use of private business information and let it hang in the air. Beverly's opening was shorter and more direct. She stated that the defendant had built her life through her own labor, that the assets listed in the complaint had been acquired through her own earnings, that the jewelry at issue had been bequeathed directly by the plaintiff's own mother to the defendant, with witnesses present, and that the court would hear evidence suggesting the lawsuit itself was not a principled claim, but a financially motivated action designed to obscure ongoing estate fraud. Hargrove was on his feet before Beverly had finished the word fraud. Objection, Your Honor. Counsel is making inflammatory allegations that have no bearing. Sit down, Mr. Hargrove, Judge Washington said, not unkindly. Counsel has the right to state what she intends to prove. You'll have your chance to challenge it. She looked at Beverly. You intend to introduce evidence on this point? We do, Your Honor. Proceed. Hargrove's first witness was my mother. Patricia Okafor on the stand was composed and practiced. She went through the financial history carefully, the ways they had supported me over the years, the specific assistance she said had been provided with the understanding that it would be returned. She described my departure from the family home and my decisions about career and marriage as a series of rejections, not just of them personally, but of the investment they had made in her. She was persuasive. I'll give her that. She had the practiced fluency of someone who had been telling a story long enough that she no longer separated it from the truth. Beverly's cross-examination was careful and measured. She established that none of the financial support provided had ever been formalized as a loan. There was no signed agreement, no promissory note, no documented repayment schedule. When Beverly asked my mother to describe the specific conversation in which she and my father had informed me that their financial support was a debt I would be expected to repay, my mother paused for the first time. It was understood, she said. In our family it was always understood. Is that a yes? Beverly asked. Did you tell your daughter explicitly that the money spent on her childhood was a debt she owed you? Another pause. It was understood. Judge Washington made a note. Then it was my father's turn. He took the stand the way he did everything, with composure, with the quiet certainty of a man who had never seriously doubted that he was the most reasonable person in the room. He talked about the family finances with fluency. He talked about the sacrifices he had made. He was good. He was very good. And then Beverly asked him about Meridian Holdings. The composure didn't shatter. It shifted, like a well-maintained facade registering a small crack, not visible to the casual observer, but apparent to anyone watching closely. Meridian Holdings was a business venture, he said. A business venture that dissolved with over $400,000 in outstanding civil judgments against it, Beverly said. Is that correct? Businesses sometimes fail. And prior to that failure, Meridian Holdings received substantial transfers from your personal accounts. Can you explain the source of those funds? Hargrove objected. The judge allowed the question. My father said the funds were legitimate business investments. From where, specifically? Beverly pressed. From various sources, including funds received from the estate of your mother, Comfort Okafor, who passed away 4 years ago. The room was very quiet. My inheritance was my own to invest as I chose, my father said. Your full inheritance, yes, Beverly said. But the question isn't about your inheritance. It's about funds that were disbursed to your uncle, Emmanuel Okafor, in exchange for the withdrawal of a probate objection. She paused. Specifically, funds that originated in the estate account before probate closed. Hargrove was on his feet again. The objection was loud and specific. Judge Washington heard it, considered it for several seconds, and then said something that sent a visible ripple through the opposing table. Overruled, she said. The witness will answer. My father looked at his attorney. Hargrove looked at the judge. And in that exchange of looks, that moment of silent recalibration, something in the courtroom changed temperature. I watched my father's jaw tighten, watched him make a calculation, watched him arrive visibly at a decision. What he said next was not what anyone at our table had expected. He said nothing. Not nothing in the dramatic sense, not a refusal, not an outburst. He said, I'd like to consult with my attorney before answering that question. Judge Washington looked at him over her glasses for a long moment. Mr. Okafor, you are currently under oath and under direct examination. This is not the appropriate procedural moment for an attorney consultation. Please answer the question. He stopped. I don't recall the specific transaction. Beverly let the silence sit for exactly 3 seconds. You don't recall transferring over $60,000 from your mother's estate account to a holding company you controlled, in exchange for your brother's withdrawal of a formal probate objection? She said. Is that your testimony? I don't recall the specific details, he said. Beverly nodded as if he'd said something illuminating, turned to her table, and picked up a stapled document. Your Honor, I'd like to enter into evidence Defendant's Exhibit F, which is a bank statement showing a transfer of $62,400 from the Comfort Okafor estate account, dated 11 days before the probate objection was formally withdrawn. The transfer recipient is Meridian Holdings LLC. She paused. The account was managed jointly by the plaintiff, Gerald Okafor, in his role as co-administrator of the estate. Hargrove's objection was immediate and technical, arguing chain of custody and relevance. Judge Washington reviewed the document herself. Beverly handed it directly to her, and then set it down on her bench. I'm going to allow it, she said. And I'm going to note for the record that this exhibit raises questions about the plaintiff's financial conduct that extend well beyond the scope of the current civil action. Her voice had not changed in volume or tone, but there was something in it now, a kind of crystalline precision, that made the room feel smaller. I am also noting that the suppression motion filed by plaintiff's counsel regarding the testimony of David Asante is denied. The NDA argument presented does not hold, for the reasons outlined in the defendant's response brief. My father sat very still on the stand. Beverly looked at Judge Washington. Your Honor, at this time, the defense would like to call David Asante. Hargrove rose again. He was a good lawyer, professional and controlled, but I could see him processing, recalibrating. Your Honor, I'd like to request a brief recess. Judge Washington looked at him. On what grounds? The plaintiff's counsel needs time to review the newly. The exhibit was filed as part of the defendant's pretrial documentation, Mr. Hargrove. You've had time to review it. A pause. Request denied. Ms. Crane, call your witness. David Asante testified for 40 minutes. He was methodical and specific. He walked through the structure of Meridian Holdings, his role in managing its accounts, and the specific transactions that had prompted his departure from the firm. He identified the estate transfers. He identified the payment to my uncle. He explained, in the careful language of a man who had spent his career with numbers, exactly what the records showed and what they meant. Hargrove's cross-examination was aggressive. He challenged Asante's motives, his professional credibility, the circumstances of his departure from the accounting firm. Asante answered each question without flinching, returning always to the documentation. It's in the records, he said more than once. The records speak for themselves. Beverly called my uncle by video link. He was in Maryland, and he gave a brief, careful statement confirming the private settlement and the withdrawal of his objection. Then Beverly called me. I took the stand, and I told my story. Not just the lawsuit, the whole story. The Easter visit. The open door. The photos. The 18 months of holding information I didn't know what to do with. I told it plainly, without drama, the way I had learned to present information in my professional life, clearly, factually, with precision. Beverly asked me about the jewelry specifically. I described what my grandmother had said. I described the note. Beverly entered the note into evidence, the handwritten original, which I had preserved, and she entered the time-stamped photographs of the jewelry I had taken after Beverly told me to check the lockbox. Then she asked me one final question. Ms. Okafor, did you steal from your parents? No, I said. Did you blackmail them? No. Did you access documents with the intent to leverage them for personal gain? No. I paused. I accessed documents that alarmed me and took photographs because I was frightened and didn't know what to do. I didn't report them. I didn't use them against anyone. I held on to them for 18 months, hoping I would never have to think about them again. Another pause. I was wrong not to report them. But I was not trying to extort my parents. I was trying to understand what my family was. Beverly sat down. Hargrove's cross-examination of me was the most difficult part of the day. He was skilled at this, at finding inconsistencies, at reframing, at asking questions that were technically answerable but designed to imply something larger. He pressed on the Easter visit. He pressed on Kayamaka. He pressed on the 18 months of silence. But the thing about building your life on truth, even imperfect truth, even truth that includes regret and confusion and the normal mess of being human, is that it holds under pressure in a way that constructed narratives don't. I had done nothing I was ashamed of. I answered every question. When Hargrove sat down, Judge Washington looked at both tables and said she was going to take a short recess before closing arguments. It was in the hallway during that recess, Beverly beside me, Nneka gripping my hand in both of hers, that it happened. My parents' attorney was at the far end of the hall, having what appeared to be an intense, low-voiced conversation on his phone. My mother was sitting on a bench with her hands in her lap, staring at the floor. My father was standing near the window. And then my father did something I had never, in 31 years, seen him do. He crossed the hallway. He walked toward me. Beverly moved slightly, and Nneka's grip on my hand tightened. I put my hand up briefly, "It's okay," and looked at my father as he stopped a few feet away from me. He opened his mouth. "Closed it." "Dad," I said quietly. He looked at me for a long time. And then he said something that I have turned over in my mind many times since, trying to understand exactly what it was, whether it was an apology, or an explanation, or something that was neither but needed to be said anyway. What he said was, "Your grandmother would have hated this." I held his gaze. "I know," I said. He nodded once, slowly. And then he walked back across the hallway and sat down next to my mother. Closing arguments resumed. Hargrove was professional, but visibly operating on reduced confidence. Beverly was precise and firm and built the closing the way you build a clean argument. Brick by brick, each one placed with care. Judge Washington took 30 minutes to deliberate. When she came back, the room was entirely silent. She read her ruling in the same clear, measured voice she had used throughout, and what she said in the first 2 minutes sent an audible stir through the gallery. But it was what she said next that made Hargrove put down his pen. And it was what she did in the final moments of the proceeding that none of us, not Beverly, not Nneka, not me, not Hargrove, and certainly not my parents, had seen coming. Judge Washington's ruling was unambiguous. The plaintiff's claim was dismissed in its entirety. She found no legal basis for the recovery of assets from a child based on the standard costs of child-rearing, absent a formal loan agreement, none of which existed. She found no credible evidence of blackmail or financial deception on the defendant's part. She found, explicitly, that the jewelry at issue had been bequeathed to the defendant by the deceased grandmother with witnesses present, and that the plaintiffs had no legal claim to it. But that wasn't the part that made Hargrove put down his pen. This was. The court finds, based on the evidence introduced by the defendant, substantial indication of potential probate fraud in the administration of the estate of Comfort Okafor, deceased. Specifically, the court finds credible documentary evidence suggesting that funds were diverted from the estate account prior to the closing of probate, in a manner that may constitute a breach of fiduciary duty and potentially criminal misappropriation. She paused and looked at my father directly. "This court is referring this matter to the State Attorney General's office for investigation," she said. "I am also referring the matter to the probate court for a formal review of the Comfort Okafor estate administration." Hargrove was indeed very still. Judge Washington was not finished. "Additionally," she said, "I want to address the conduct that occurred in the lead-up to this proceeding. It is on record that the plaintiff, Gerald Okafor, placed a phone call to the defendant's employer prior to the hearing, making allegations designed to damage her professional standing. It is also on record that the plaintiff's legal team filed a complaint against defense counsel with the Ohio State Bar, subsequently assessed by that body as frivolous. This court views these actions as consistent with a pattern of intimidation directed at the defendant." She looked at Hargrove and then at my parents. "I am awarding the defendant attorney's fees and court costs, to be paid by the plaintiffs." She removed her glasses and set them on the bench. "I want to say one thing for the record," she said, and her voice had shifted slightly, still formal, but carrying something underneath it that the room could feel. "I have presided over family litigation for many years. I have seen parents and children cause each other genuine harm in many directions. I have sympathy for the difficulties of family breakdown in all its forms." She paused. "What I do not have sympathy for is the weaponization of the legal system as a tool of financial exploitation against one's own child. This court's purpose is not to be an instrument of control. The claims filed in this case were not made in good faith. The evidence introduced did not support them. And the conduct surrounding this filing, including the deliberate placement of an informant in the defendant's personal life, reflects a degree of premeditation that this court finds deeply troubling." She set down her papers. "Case dismissed." Referral to the AG's office stands. Bailiff. She called for security not with drama, not with shouting, but with the quiet authority of someone who has decided that a line has been crossed and that the mechanism of consequence is now appropriate. 2 officers were in the room before Hargrove had finished leaning toward my father to explain what had just happened. My parents were not arrested. I want to be clear about that. The bailiff was called because my father had risen from his seat and was speaking in a raised voice that Judge Washington had cut through once sharply. "Sit down, Mr. Okafor." And when he had not, she had called for the officers to escort them from the courtroom. My mother went quietly. My father went with the stiff, controlled fury of a man who has spent his life maintaining an image and has just watched it become something he no longer recognizes. The door closed behind them. The gallery exhaled. Nneka had both hands over her mouth. Beverly was writing something in her journal with great calm. I sat at the defendant's table and looked at the spot where my parents had been sitting and let the silence of the room settle around me. I want to tell you I felt triumphant, that there was a clean, rising feeling of victory that completed the arc. What I actually felt was more complicated and more honest than that. I felt tired, the particular tiredness of a long effort finally concluded. I felt grief, not for what I had lost in that courtroom, but for what had been lost long before it, in a house in Dayton over 31 years of transactions disguised as love. I felt something that was adjacent to relief, but wasn't quite relief yet, more like the moment after a fever breaks, when you are not yet well but you can feel the direction you are moving. And I felt my grandmother. Not mystically. Not supernaturally. I felt her the way you feel someone when you know they would have had a clear opinion about what had just happened. She would have been furious at her son, a deep, dignified fury that wouldn't have required shouting. She would have been sad in the way she was always sad about things she saw coming and couldn't prevent. And she would have looked at me the way she always looked at me, with that direct, undeceivable gaze, and said, "I told you. Don't let anyone take them from you." I had not let anyone take them. Not the jewelry. Not my house or my car or my savings or the 7 years of work I had built into a career. Not my reputation, which had survived my father's call to HR intact. Dr. Wells had already sent me a message that morning saying the review was closed, no action taken. Not my sense of myself, which had been tested in the last months in ways I hadn't known were coming and had held. Beverly drove me home that afternoon. We didn't talk much. She updated me on the next steps, the AG referral process, the probate court review, what those things would mean in practical terms over the coming months. And I listened and asked the right questions and noted the important things. At my door, she shook my hand. "You did well," she said. "You kept your head when it mattered." I had good help. She smiled, a small, precise smile. "You did," she agreed. Nneka came over that evening with wine and takeout from the Thai place we had been eating from since college, and we sat on my living room floor because neither of us wanted to be at a table, and we ate and talked about everything and nothing, and eventually stopped talking and just sat. I opened the lockbox before I went to bed that night. I held my grandmother's gold chain in my hand for a moment. It was thin and weightless, and warm from my palm almost immediately. I thought about everything it had taken to keep it. I thought about the morning it had been pressed into my hands, and the note, and the particular clarity of a dying woman who had spent a long life watching people she loved and knew exactly what they were capable of. I thought about how she had known this day might come, and how she had done the only thing she could do. Given it to me herself, with witnesses, with words, with a written note in her own hand, and trusted me to hold it. I had held it. I put the chain back, closed the box, turned out the light. Outside, the October trees were bare now, the last of the copper leaves gone, and the neighborhood was quiet and dark and entirely ordinary. My house sat where it had always sat. My life was where I had built it. The ground beneath my feet was mine. I had built it, and I was keeping it.